Good morning.
Good morning, judges.
Morning, Your Honors.
Good morning. So we are now here on the case of White v. Durrani, which is case number C190402. If both parties can please state their names and readiness to proceed.
Good morning, Your Honor. Robert A. Winter Jr. on behalf of the plaintiff's appellants.
Philip D. Williamson on behalf of defendants appellees. Ready to proceed.
Thank you. Attorney Winter, would you like to reserve time?
Yes. Before we get started, judges, there was some question pre-argument about the absence of a video that the trial court reviewed of a collage of Dr. Durrani's testimony, and attorney Paul Volman on behalf of appellees and I were trying to assemble that video for the court, and very recently Mr. Volman said, you know, my words, not his, why do you all need it? And
well, it's part of the, it says it was played to the jury. The transcript says it was played to the jury.
Okay, and I wanted to find out first, if are you satisfied with what is before you, and do we owe the court anything to make the record complete for your decision?
Judge Zayas, could I speak to that just briefly, generally?
Sure.
I guess I would say, Mr. Winter, that we can only decide a case on what is for us, and that is my understanding is that the record before us does not contain that information, that testimony that was played to the jury.
That's my understanding too. I received a phone call from one of your staff members asking us to assemble it, and we're in the process of doing that. And I'm prepared to submit that item. I was hoping to get it on a stipulated basis from Mr. Volman, and we're kind of at a standstill right now. The feeling that he had, if I can speak for him, is that he didn't know why it was needed. But I can, if he still holds those views, I can file a motion to supplement the record and be done with it. And whatever the court's pleasure is. And the reason why I kind of asked the court for guidance is that's where the request came from in the first instance.
I think, Mr. Winter, I've probably given you all the guidance.
Yes.
And I guess the panel can discuss any remaining issues, and if appropriate, someone will get back to you.
Okay, fine.
Thank you.
I guess it's my turn to start. Couple minutes.
2 minutes.
Okay, good. This is another trial of a medical malpractice case. It was tried. At the end of plaintiff's case, the defendants appellees moved for directed verdict. They had, and which was granted. They had previously received a summary judgment on my client's claims for vicarious liability, and what was tried is liability of direct negligence by Dr. Durrani, and we appealed from that. I just wanted to just kind of set the stage. Dr. Shawnee was an employee of Center for Advanced Spine Technologies at the time, and Dr. Durrani was, it was his practice group. He was the owner. There was a surgery performed on Sophia White, my client, on November 12th of 2012. It was performed by Dr. Shawnee, and the plaintiff's surgeon experts, Dr. Bloomfield and Dr. Siani, criticized that surgery as being not medically indicated, not necessary. And the trial judge at the close of the case said that there was no evidence that supported liability on behalf of Dr. Durrani. And I wanted to point out the evidence that was before the court. Dr. Shawnee testified that Dr. Durrani was directly involved in the planning and formulating recommendations of the surgical procedures to Ms. White. Dr. Shawnee executed those plans, but Dr. Durrani was directly involved, and that's at his deposition at TP 25. I think we cited that in our record. The surgery that was originally planned was a left-sided L5-S1 laminectomy, laminectomy and discectomy. What was actually done was a bilateral L5-S1 laminectomies and foramectomies. There was no discectomies, discectomy of L5-S1. That changed.
So which surgery did Dr. Durrani recommend?
Both.
The one that happened as
Both.
well? Okay.
The original one, and then the change.
And the evidence is based upon that statement from Dr. Shanti's deposition that you pointed to. That's the only evidence
Yes.
of his involvement.
Dr. Durrani didn't avail himself of attending a trial for the reasons we've discussed. Yes, it was Dr. Shawnee who said that Dr. Durrani was intimately involved in the recommendations for the surgeries, plural. Again, Dr. Bloomfield said that the surgery was not medically indicated, and both of them would have had risks and dangers that actually materialized for Ms. White.
So part of your position is that the directed verdict was not appropriate because there was evidence that there was a duty of care, specifically that Durrani was involved in the decisions and the recommendations of the surgeries.
Yeah, let me back up one, Judge, and also say it's my burden to show that there was a physician-patient relationship in the first place. And then we go on to the items that you discussed. And I think that Dr. Shawnee's testimony started that proof, and then is part of that physician-patient relationship. Dr. Durrani attended to Ms. White and assessed her condition either in the recovery room or shortly afterwards. He assessed her ability to ambulate, and whatever he put in the record, he put in the record. So, I mean, he wasn't a stranger to this relationship. He was part of the physician-patient relationship. That's where we part company with the trial court. It should have gone to the jury. Maybe the jury would have found for Dr. Durrani.
So
I don't think so.
The facts that you're pointing to with regard to the directed verdict, are you saying that there's a doctor-patient relationship as a matter of law or as a matter of fact?
Matter of fact. Sure, it's a matter of fact. Yes. Yeah, I can't say that there was a matter of law relationship, a physician-patient relationship. I have to prove that. And we put on the proof with Dr. Shawnee and with Ms. White. And he recommended two non-indicated surgeries that were unnecessary, causing her harm. So I think that the trial court attorneys for Ms. White put on enough to require Dr. Durrani to put on his case in chief and go on and get a jury verdict. And it is inappropriate under Rule 50A to direct a verdict because there was evidence. Second point was we appealed for the motion for summary judgment. I stand by my brief on that, but I did need to point out that there's a case called Rush versus the University of Cincinnati Physicians that deals with this respondeat superior concept. It's a paragraph 22 and 23, and our Justice DeWine stated that the employer in that case, UC Physicians, could not be held vicariously liable for the conduct of an unnamed physician. And along the way, Justice DeWine said that he explained that only individuals practice medicine and only individuals can commit medical malpractice, citing Browning versus Burke. So that I wanted to alert the court to that.
Attorney Winter, I have a question with regard to the summary judgment.
Yes.
Okay. In your brief on page 10, you include in there the discussion from the bench with regard to the hearing. And in there, the court.
I'm sorry, let me get there. Hey, I'm at page 10, please.
Okay. So at the very first paragraph, it talks about the determination of summary judgment for vicarious liability, negligent supervision, or negligent training. So there was a claim of negligent supervision and training that was asserted, right? In addition to vicarious liability.
Negligent hiring, training, yes.
Yes.
No.
So did the summary judgment dispose of both of those
Yes.
claims?
Yes.
Okay. So are you asserting, is your assignment of error, does it go to the summary judgment's decision on both of those claims or only the vicarious liability?
Only vicarious liability, Your Honor.
Okay, so you're not appealing the decision on the summary judgment with regard to the negligent supervision and training?
Oh, I think that was all in one, because there was a release of by my clients of Dr. Shawnee. Okay, and there are consequences to that. And that includes I believe that dealt with the negligent training and those things.
I'm not sure I just want, my question is whether you are appealing the summary judgment on both of those claims or on one of those claims.
My understanding is that we were appealing the grant of summary judgment on the vicarious liability claims for Cass and Durrani.
Okay. But not on the negligent supervision and training on CAST.
Yeah, I don't think that ever worked. No. Correct.
Mr. Winter, you referenced that there are implications to settling with Dr. Shanti. Isn't one of the implications that if he can't be held liable, the employer can't be held liable?
I think that's one of the implications in the Rush case.
And that once released, then CAST and Durrani as an employer don't have any liability either once you've settled with him and the claims have been released.
Well, except for the direct claim that we have against Durrani and Cass for Durrani's wrongdoings.
Okay.
Cass is still in the. Yeah, it's okay. Thank you. Yeah. But that's what I have that summarized 15 pages of brief into 2 minutes of oral argument, judges. Thank you.
Thank you. Attorney Williamson, good morning.
Good morning, Your Honor. I have all of my notes on the computer, which is why
Okay,
you see me
whenever
glancing
you're
over this
ready.
way. At the heart of every tort claim, one irreducible question is, what did the defendant owe to or do to the plaintiff? And I submit, Your Honors, in this case, the answer is nothing. So Mr. Winter pointed to two pieces of evidence suggesting that Dr. Durrani established a physician-patient relationship with Mrs. White, and I submit neither of those stand up. The first is this comment from Dr. Shanti on page 25 of his deposition. Your Honors, as I think we stated in our brief, plaintiff's entire case here rests on whether the court reporter put a comma or a period in this spot. The court reporter used a period, and that's why plaintiffs suggest that Dr. Shanti says that Dr. Durrani was involved. But I think if you read the entire page of the transcript and then on to page 26, it's clear from the context that Dr. Shanti's actual answer was, I don't recall that in this specific case, he, that is Dr. Durrani, was directly involved in the recommendation to perform surgery on Mrs. White.
Well, don't we even have available to us the video deposition that we can actually listen to what he said, as opposed to relying on the transcript?
That's correct, Your Honor.
That was played at trial, right?
I believe so, yes, Your Honor.
I would suggest that perhaps there's even, that it's not 100% accurate, but I think the jury could have listened to it and determined what it said. Would you agree with that? The jury didn't have the transcript in front of them. They had the actual video. So it doesn't matter. I guess my point is, it doesn't matter what the transcript says.
Yes, the jury could have listened to the video. In fact, did listen to the video and could have decided whether they thought there was a comma or a period there.
I asked a very poor question. What I really meant to say is it was played during trial, and the court, as well as the jury, was able to actually hear the testimony and did not need to rely on a transcript.
That's correct, Your Honor.
Couldn't have relied on the transcript because it wasn't before the court or the jury.
That's correct, Your Honor. And given that, I think the rest of the testimony, and in fact, the very next question from plaintiff's counsel in the deposition confirms that Dr. Shanti's actual testimony is, I don't recall Dr. Durrani being involved in this case. Because the very next question is, all right, well, it wouldn't be unusual for Dr. Durrani to be involved. Well, you wouldn't ask that question if the witness had just told you that Dr. Durrani was in fact involved in this particular case. I submit the next sort of 2.5 pages of the transcript don't make any sense if Mr. Winter is right about this particular answer. The second sort of item that Mr. Winter points to is that Dr. Durrani appears in Mrs. White's room after her surgery, watches her walk down a hallway and back, and leaves. And from sort of a misplaced period and a passive observation, we're supposed to conclude that Dr. Durrani was Mrs. White's treating physician. Your Honor, it just doesn't work.
Because ultimately the issue is whether Dr. Durrani was the treating physician as for the surgery.
That's correct, Your Honor.
So for some reason, something had arisen during that whatever few-minute interaction that that Durrani had in the hospital, then potentially there could have been a sort of a patient-client as to that moment and a breach at that moment. But we're not talking about that. We're talking about the surgery.
That's correct, Your Honor. I think it's also clear from Mrs. White's own testimony that Dr. Durrani had nothing to do with the planning and execution of her surgery. She never met with him. She never consulted with him. She treated exclusively with Dr. Shanti prior to her operation. Dr. Shanti was the person responsible for going over her informed consent form. You simply don't see Dr. Durrani make an appearance in Mrs. White's care and treatment. And so no reasonable jury could have taken the evidence presented by plaintiffs at trial and found Dr. Durrani liable. It's simply not there. And I think that goes to the informed consent claim as well, because Dr. Durrani only has a duty to secure Mrs. White's informed consent if she's actually his patient and he is the one actually performing the surgery. And I think it's clear from the record in this case that that simply didn't happen. I want to touch briefly on the fraud claim, which arose from the alleged bills sent from CAST to, not to Mrs. White, but actually to the Workers' Compensation Bureau. Again, going back to that key question, what did the defendant do to the plaintiff? And in this case, nothing. No one sent any bills to Mrs. White. She could not possibly have been induced to do anything by any representation in a bill that she did not see. She testified, in fact, that she saw the bills for the first time at trial in 2019. We are talking 6.5 years removed from her surgery. She is seeing the bills for the first time, which incidentally, Your Honors, means that Mrs. White drafted a complaint alleging fraud based on bills she had never seen when she filed the original complaint. I submit there's nothing here to base a fraud claim on. And if Your Honors have no questions on that, I'll move on to vicarious liability, which is very straightforward. In order to have vicarious liability, you must have direct liability. And there is no direct liability of Dr. Shanti, the actual physician in this case, that could flow up to CAST. Mrs. White settled for her own reasons with Dr. Shanti with no finding of liability or malpractice. So it would be at this point impossible to hold Dr. Shanti liable for malpractice. And because he can't be liable, the case law is very clear, as Mr. Winter referred to the Rush case. If he can't be liable, then neither can his employer.
Thank you. Unless there's any other questions from the panel. Thank you for your arguments this morning. Attorney Winter.
Just a couple points. If there was a video played to the jury and they heard it and they were deprived of the opportunity to come to the conclusion that Mr. Williamson would want the jury to come to, the jury
Well,
should have.
Mr. Winter, what if it's so clear that the judge could make a determination of where the punctuation was? The judge presumably didn't even have the transcript.
No, but he saw the video, and so did the jury.
And I guess I'm saying, what if the transcript's wrong, is my question to you.
The jury should have then been granted that opportunity to tell us that it was wrong, or that it was right.
Well, they wouldn't have seen the transcript, so they.
Right, but they would have heard Dr. Shawnee say what he said on Dr. Durrani's recommendations or lack of recommendations or non-participation. But
I'm sorry to interrupt.
I just want to answer the question that if all these grand things against Ms. White are true and in favor of Dr. Durrani, then it would have been the issue is presented. The jury, it's a question of fact. They should have decided that either in White favor or Durrani favor.
Let me just throw out a hypothetical to you. Let's say that the court reporter in a different transcript made a mistake, and the testimony actually was, she was my patient. And let's say that the court reporter put a not in there and said, she is not my patient. And the trier of fact and the court didn't have the transcript in front of them. They just heard what it said. I assume you wouldn't be arguing that the jury should determine whether that "not" was really there, even if it was in the transcript.
That actually happened, something similar to me once, and the jury decided it.
Based on not the transcript, I assume, based on
That's right,
what
the
they
video,
heard.
the
Yeah.
video, that's right. And they should have had it here. The second point I want to address is if Dr. Durrani was in the patient room doing care and treatment, that's a physician-patient relationship. I mean, what's he doing there? If
Is that enough? I mean, if we were to maybe disagree with you on the first point
Mhm.
of what Dr. Shanti said, is it enough that Dr. Durrani was there once and had her walk up and down the hall is that enough evidence to go to a jury?
he was assessing the physical capabilities of my client, yes.
But what was the negligence? What fell below the standard of care?
The making the recommendation and then planning the two surgeries. They were not necessary. They were not indicated. Doctors Bloomfield and Siani made that clear. They should never have been done. And Durrani was directly involved in the planning and recommendation to Ms. White to undergo the discectomy surgery. And then they planned and had surgery number 2 without the discectomy. Durrani was involved in that. That's the negligence.
Dr. Shanti's deposition testimony is key in this case. I mean, it's not really Dr. Durrani being there when she wakes up and having her walk. It's his deposition testimony that is the key to your case.
Well, it's his assessment of her physical capability of her lower extremity is evidence of the already existing patient-client relationship. That's an issue of fact. Jury should have tried it or decided it, excuse me. We tried it.
So what you're saying is Dr. Durrani watching your client walk after the surgery bolsters whether Dr. Durrani was in fact involved in the performance and recommendation of the surgery.
Yes, he's making an assessment, assessing her ambulating.
But isn't that commonplace for a doctor to be the one to make the recommendation and performance, and perhaps the doctor on duty at the hospital will come by and check on the patient?
But he was just not a mere, house doctor. He had a relationship with Cast. He had a relationship with Dr. Shanti, and he wasn't there by mere happenstance. He was there immediately after the surgery.
I mean, this I think goes back to Judge Krause's point, is that it all comes back to Dr. Shanti's statements during the deposition, whether Dr. Durrani was truly involved in any decision-making in the recommendation of the surgery or not.
I got a little bit of weight due to the assessment, but I would think that the fact finder would place great weight on that.
Thank you. Unless there's any other questions from the panel? Okay, we will take the matter under submission and issue the timely decision. And we
Judges, thank you for your time.
And thank you both. And we wish you both a wonderful afternoon. Maybe we'll
Thank
get
you,
a
Your
little
Honors.
bit of sunshine today.
Same to you, Judge. Judges, take care. Thank you.
Take care.